So we've talked about in a previous video around buy-sell agreements, what they are, how to fund them, and the Connolly vs. US Supreme Court case every business owner should know about. But that video, like almost every buy-sell agreement video on YouTube, focused primarily on death and disability. What happens when an owner dies? What happens when an owner becomes incapacitated? Those are critical scenarios, but they are not the only ones. Today, I want to talk about a scenario that is equally common, equally damaging, and almost entirely ignored in most buy-sell agreements. What happens when you and your business partner simply can't agree anymore? I'm at Losanno with Cinder Wealth. Quick disclaimer, this video is educational only, not legal, financial, or tax advice. Business disputes scenarios are highly specific to your situation and your legal documents. Always work with a qualified attorney on your buy-sell agreement and business structure. Here's why the disagreement scenario gets so little attention. When you start a business with a partner, you're optimistic. You like each other, you have aligned goals, you're building something together. Nobody sits down on day one and thinks, let's plan for the day we hate each other. But business partnerships are long-term relationships, and like any long-term relationship, people change. Goals diverge. One partner wants to grow aggressively. The other wants to stay a manageable size. One wants to sell. The other wants to pass the business to their kids. One is reinvesting everything. The other wants to start taking some distributions. These disagreements are not rare. They are predictable, and they are almost never planned for. The technical term for a situation where business partners cannot reach a decision is a deadlock. And in a 50-50 partnership, without a deadlock resolution mechanism, a deadlock can effectively freeze decision-making in the business. Neither partner can force a resolution. Neither partner may have a clear path to force a resolution or a buyout. The business sits in limbo while the relationship deteriorates and the company loses value. I've seen businesses survive recessions and market downturns get completely derailed by this exact scenario. Not because anyone was bad, because there was no roadmap. Let's talk about what most buy-sell agreements actually address. The typical buy-sell covers death. What happens to the deceased owner's shares? Who can buy them? At what price? Funded by life insurance. Disability. What happens if an owner becomes permanently incapacitated? It's a similar buyout mechanism. Voluntary sale. If an owner wants to sell their shares to a third party, the agreement typically gives remaining owners a right of first refusal. And retirement. What happens when an owner reaches retirement age and wants to exit? These are all important, and a well-drafted, properly funded buy-sell agreement is far better than nothing. But here's what many agreements miss or inadequately address. Deadlock resolution. What happens when two 50-50 owners simply cannot agree on a major business decision? A voluntary buyout triggered by a disagreement. If one owner decides they no longer want to continue the partnership, what's the process? What's the price? Who has the right to buy out who? Performance-based triggers. What happens if one partner stops contributing meaningfully to the business, but refuses to sell their stake? Behavioral triggers. What if one partner engages in contact that may harm the business, but doesn't clearly trigger a legal breach under the agreement? Most business owners have never read their buy-sell in full. They signed it when their attorney told them to and filed it away. And the provision that would actually govern a dispute scenario are often vague, outdated, or entirely missing. So what should a buy-sell agreement have to address this scenario? So let's walk through the main tools. Tool 1, the shotgun clause, also called a buy-sell trigger or a Russian roulette clause, depending on your attorney's creativity. Here's how it works. If a deadlock is reached or one partner triggers the clause, partner A names a price at which they are willing to either buy or sell. Partner B then chooses to buy at that price or sell at that price. Because neither party knows whether they will be the buyer or the seller, the name price is designed to encourage a fair behavior. Nobody wants to name a lowball price and end up selling at it, or name an inflated price and end up buying at it. This can be a simple and effective mechanism in the right situation, but it only works if it's in the agreement and both parties understand it exists. Tool number 2, the appraisal process. Rather than relying on a formula or a fixed price, the agreement calls for an independent business appraisal when a buyout is triggered. Each side can bring their own appraiser, and a third appraiser is used if they disagree. This can take longer and cost more than a shotgun clause, but for larger businesses, it often produces a more defensible valuation. Tool 3, the right of first refusal combined with a forced buyout provision. If disagreement reaches a specified threshold, either party can trigger a formal process where one partner must buy out the other within a defined time frame at a specified valuation method. This creates a resolution pathway without requiring both parties to agree, which is the whole problem in a deadlock situation. But here's the key. Any of these mechanisms only work if the buyout is funded. And many buy-sell agreements, if they have these provisions at all, have no clear funding mechanism for the dispute scenario. Life insurance funds the death buyout, but what funds the dispute buyout? The answer is often missing. And when it is missing, the partner who wants out is stuck waiting for the other partner to come up with cash, get a business loan, or negotiate a plan, which takes time. Here's something I want to call out directly because it connects to everything I talk about. Business partner disputes are where advisor coordination often breaks down until it is too late. The attorney drafted the buy-sell years ago. The financial advisor manages the investment accounts. The CPA handles the taxes. Rarely have all been in the same room to think through what actually happens in a dispute scenario and whether the business has the liquidity to handle a buyout. When a dispute happens, suddenly everyone is involved. The attorney is reviewing the agreement, the CPA is figuring out the tax implications of a buyout structure, the financial advisor is modeling what the exiting partner's finances look like after the transaction. They're all reactive. None of them were proactive. And in the meantime, the business is suffering. The relationship between the partners has broken down, clients are noticing, employees are nervous. The scenario I just described is preventable, not by predicting who will disagree or when, but by building a clear, funded, documented resolution pathway before any disagreement happens. When there's a roadmap, a dispute becomes a transaction. Without a roadmap, it becomes a war. Here's what I want you to walk away with. If you have a business partner, pull out your buy-sell agreement, read it. Specifically look for these things. 1. Is there a deadlock resolution provision? If two equal partners cannot agree on a major decision, how does that get resolved? 2. Is there a voluntary buyout provision triggered by disagreement? Not just death or disability. If one partner decides they want out, what's the process? 3. Is the dispute buyout funded? Life insurance funds the death buyout. What funds the dispute buyout? 4. When was this agreement last reviewed? If the business has grown significantly since it was drafted, the valuation method and the coverage amounts may be outdated. And 5th, have your CPA, financial advisor, and attorney ever been in the same room to discuss this agreement? Because the tax implications of a buyout, the funding strategy, and the legal provisions, they all need to work together. If any of those answers are no, or I don't know, that is worth a conversation with your attorney before you need the answer. Please subscribe for more content on business continuity and wealth planning for business owners. I'm Matt Losanno with Cinder Wealth. Thanks for watching.